The statement, unless stated otherwise in Article 2 of the Civil Code, does not mean that a publication in the Official Gazette is not needed when effectivity date of the law is already stated. The statement, unless stated otherwise, actually pertains to the effectivity date of the law and not to the publication in the Official Gazette. Welcome to the LawKey podcast, where you can listen and review case digests and get practical tips on how to survive law school in the Philippines. Studying law can be very challenging, especially for working students, but with the right tools, the right habits, and the right support group, we can surely survive it. This is Kim, your host, and I hope you enjoy and learn something from this episode. Here we go. Hi everyone, today is our first episode and we are going to be talking about the case of Lorenzo M. Tanada versus Honorable Juan C. Tuvera with GR number L-63915, decided on April 24, 1985. This is a case focusing on the subject persons and family relations. So first years, this is for you. Let's start. So the facts of this case are there were various presidential decrees, letters of instructions, general orders, proclamations, executive orders, letter of implementation, and administrative orders that were not published in the Official Gazette. So the petitioners the petitioners then invoke the people's right to be informed on matter of public concern that's recognized in Section 6, Article 6 of the 1973 Constitution, as well as invoke the principle that for laws to be valid and enforceable, it must be published in the Official Gazette or otherwise effectively promulgated. So with this, petitioners then seek a writ of mandamus to compel respondent public officials to publish or cause the publication in the Official Gazette of the mentioned presidential issuances. Now, we actually have two issues in this case. The first issue would be whether or not petitioners have the legal personality as the aggrieved parties to institute mandamus proceeding according to Section 3, Rule 65 of the Rules of Court. The second issue is whether or not the publication in the Official Gazette is not an essential requirement for the effectivity of laws where the law themselves actually provide for their own effectivity dates as reliant to Article 2 of the Civil Code. Now, let's first tackle the first issue. It's whether or not the petitioners do have the legal personality to bring the writ of mandamus petition. So, the respondents, through the Solicitor General, actually contended that the petitioners don't have the legal personality because they are not personally and directly affected or prejudiced by the alleged non-publication of the presidential issuances in question, because said petitioners are without the requisite legal personality to institute this mandamus proceeding because they are not the aggrieved parties within the meaning of Section 3, Rule 65 of the Rules of Court. The petitioners, however, said that since the subject of the petition concerns a public right and its object is to compel the performance of a public duty, then they actually don't need to show any specific interest for their petition to be given due course. Now, let's first take a look at what does Section 3, Rule 65 of the Rules of Court say. So, Section 3, Petition for Mandamus. It says that when any tribunal, corporation, board, or person unlawfully neglects the performance of an act which the law specifically enjoins as a duty resulting from an office, trust, or station, or unlawfully excludes another from the use or enjoyment of a right or office to which such other is entitled, and there is no other speedy and adequate remedy in the ordinary course of law, the person aggrieved thereby may file a verified petition in the proper court, alleging the facts with certainty and praying that judgment be rendered, commanding the defendant immediately or at some other specified time to do the act required to be done to protect the right of the petitioner and to pay the damages sustained by the petitioner by reason of the wrongful acts of the defendant. So again, based on Section 3, Rule 65 of the Rules of Court, respondents contended that petitioners are not the aggrieved parties according to Section 3 because they are not directly and personally affected or prejudiced by the alleged non-publication of the presidential issuances. Now, what does the court say about this argument? The court held that this was decided on the 1910 case of Severino versus Governor General. It was held that while the general rule is that a writ of mandamus would be granted to a private individual only in those cases where he has some private or particular interest to be subserved or some particular right to be protected independent of that which he holds with the public at large. Nevertheless, the exception is that when the question is one of public right and the object of the mandamus is to procure the enforcement of a public duty, the people are regarded as the real party in interest and the relator at whose instigation the proceedings are instituted need not show that he has any legal or special interest in the result, because it being sufficient to show that he is a citizen and as such interested in the execution of the law. So again, according to the court, although the general rule is that a writ of mandamus should only be granted to private individual who has some particular interest to be subserved or particular right to be protected, but with the exception that if the question is one of public right and the object of the mandamus is to enforce a public duty, then the petitioner need not show that he has any legal or special interest, because being a citizen is already enough, and as such, he is already entitled. Furthermore, the court also said that clearly the right sought to be enforced by petitioners herein is a public right recognized by no less than fundamental law of the land. If petitioners were not allowed to institute this proceeding, it would indeed be difficult to conceive of any other person to initiate the same, considering that the Solicitor General, the government officer who is empowered to represent the people, has actually entered his appearance for respondents on this case. So again, the ruling of the Supreme Court for the first issue is that the petitioners do have the legal personality to petition for the writ of mandamus, because the question in this of the mandamus is a public right. Thus, being a citizen is already enough for this case. Now, let's move on to the second issue, which is whether or not the publication in the Official Gazette is not an essential requirement for the effectivity of laws, where the laws already provided for their own effectivity dates as reliant to Article 2 of the Civil Code. So, here, the respondents contended that publication in the Official Gazette is not a sine qua non requirement, meaning not an essential condition for the effectivity of laws where the laws themselves already provided their own effectivity dates. It is thus submitted that since the presidential issuances in question in this case already contain a special provisions as to the date they are to be taken effect, then the Official Gazette is not an indispensable for their effectivity. They have stressed out Article 2 of the Civil Code, which says that laws shall take effect after 15 days following the completion of their publication in the official gazette unless it is proven otherwise. Now, the Supreme Court said that considered in the light of other statutes applicable to the issue at hand, the conclusion is easily reached that Article 2 does not prevent the requirement of publication in the official gazette even if the law itself provides for the date of its effectivity. It's stated in Section 1 of Commonwealth Act 638, which says that there shall be published in the official gazette 1. All important legislative acts and resolution of a public nature of the Congress of the Philippines. 2. All executive and administrative orders and proclamations except such as have no general applicability. 3. Decisions or abstracts of decisions of the Supreme Court and the Courts of Appeals as may be deemed by said courts of sufficient importance to be published. 4. Such documents or classes of documents as may be required as to be published by law. And 5. Such documents or classes of documents as the President of the Philippines shall determine from time to time to have general applicability and legal effect, or which he may authorize so to be published. The word shall used therein imposes upon respondent officials an imperative duty. Then the duty must be enforced if the constitutional right of the people to be informed on matters of public concern is to be given substance and reality. The law itself makes a list of what should be published in the official gazette. Such listing, to our mind, leaves respondents with no discretion whatsoever as to what must be included or excluded from the publication. So the Supreme Court also said that the clear object of the Section 1 of Commonwealth Act 638 is to give the general public adequate notice of the various laws which are to regulate their actions and conduct as citizens. Without such notice and publication, there would be no basis for the application of the maxim ignorantia legis non exusat. It would be the height of injustice to punish or otherwise burden a citizen for the transgression of a law of which he had no notice whatsoever, or not even a constructive one. Thus, it only means that without publication, the people would have no means of knowing what presidential decrees actually have been promulgated, and because they have no means of knowing the laws that were already promulgated, then they shouldn't be held accountable for the maxim ignorantia legis non exusat. So this maxim was stated on Article 3, which says that ignorance of the law excuses no one from compliance therewith. So no publication would mean that the citizens will not be held accountable under Article 3 of the Civil Code. Furthermore, the Supreme Court also said that it is needless to add that the publication of presidential issuances of a public nature or of general applicability is a requirement of due process. It is a rule of law that before a person may be bound by law, he must first be officially and specifically informed of its contents. That's also according to Justice Claudio Tihanqui on Peralta versus Comelec. In a time of proliferating decrees, orders, and letters of instructions, which all form part of the law of the land, the requirement of due process and the rule of law demand that the official gazette, as the official government repository, promulgate and publish the text of all such decrees, orders, and instructions so that the people may know where to obtain their official and specific contents. So, in short, the court hereby orders respondents to publish in the official gazette all the unpublished presidential issuances which are of general application, and unless so published, they shall have no binding force and effect. Again, to reiterate, the statement, unless stated otherwise in Article 2 of the Civil Code, does not mean that a publication in the Official Gazette is not needed when effectivity date of the law is already stated. The statement, unless stated otherwise, actually pertains to the effectivity date of the law and not to the publication in the Official Gazette, because the publication of law is mandatory. It is an imperative duty, so the Article 3, which is ignorance of the law excuses no one of the Civil Code, will have basis. And it only means that when effectivity of the law is stated, it means that a publication of the Official Gazette must be done prior to the effectivity date mentioned in the law. But if there is no effectivity date mentioned, it shall take effect 15 days after it was published. So in short, the publication is still required either way. So that's for Tanada versus Tuvera. That's it for today's episode, guys. By the way, if you want to get a copy of the full text of the case, highlighting the important details I mentioned earlier, you may want to check this podcast description for the link. Thank you for listening and talk to you next time. Bye!